us have it.
Hello and welcome to the program. I am Dennis Adegunloye. It has been an eventful week at the National Assembly, to say the least, with the House backtracking on its earlier decision on some constitution amendment bills, including those relating to gender. And the Senate in the week refused to be cowed by the judiciary, saying the court has no constitutional right to stop the legislative arm of government from carrying out its functions such as lawmaking. Senate President Ahmed Lawan stated this at plenary of Tuesday, 8th of March, while reacting to the ruling by the Federal High Court sitting in Abuja, restraining the National Assembly from going further to amend the new Electoral Act 2022. He explained that the doctrine of separation of powers in the Nigerian Constitution conferred on the legislature the function of making and amending laws brought to it by individual members or the executive, and any attempt to interfere with this constitutional duty would amount to an infringement of constitutional provisions.
There's clear-cut separation of powers, and I mean separation and exercise of powers. The judiciary, under no circumstance, can stop the legislature, the National Assembly, from performing its legislative duties.
I think the argument you have raised is valid, but this one will present in court to discharge that order. We cannot sit and appeal here on a matter that's already been given an order in court. So I think that we should exercise caution in sitting the judgment over a matter that a decision has been given, or at least an order has been given.
If the judiciary wants to come into the legislature and decide when we sit and when we don't, then there's anarchy. If the judiciary will simply say we are not to consider this and that, and we obey those kind of rulings, that's anarchy. Because it's emasculating the legislature, and that's not supposed to be. So we will continue with what we are supposed to do, because that is our calling. We are just advising that the judiciary should please help us develop this democracy.
Now, an issue in the new Electoral Act 2022 that has generated much debate is Section 84, subsection 12 of the new law, which, of course, President Muhammadu Buhari expressed his reservations about to the Senate. However, the legislators were decisive on this provision, and the matter has now been put to rest.
This provision has been interpreted by the executive arm of government as introducing qualification and disqualification criteria that are ultra-violating the Constitution by way of importing blanket restriction and disqualification to serving political office holders.
At the beginning of Section 84, that says that no political party shall seek to disqualify anybody by importing into the process a provision for qualification or disqualification not otherwise provided for in the Constitution. It is there at the beginning. I believe that's Section 84, Section 84(2). You cannot be a referee and a player in the same field. It's either you're a referee or you're a player. It's a settled matter in law that you cannot be a judge over your own case.
I've listened enough. So I will put the question, and every one of us is at liberty to vote his conscience. Those in favor that this bill be now read a second time, say aye. No, maybe you didn't hear me. No. Those in favor that this bill be now read a second time, say aye. Those against say nay. I put the question. There was an aye and there were nays. And I said the nays had it.
Now, the Senate is set to put to rest the jurisdictional conflict between the Bureau of Public Enterprises and the Infrastructure Concession Regulatory Commission, as it held a recent public hearing on a bill to repeal the ICRC Act and to enact the Public-Private Partnership Regulatory Commission. Here are extended highlights of that public hearing.
This bill is people-oriented. This is because it seeks to facilitate private sector investment in the provision and maintenance of both new and existing infrastructure in an effective and efficient manner. It is meant to attract private and public financial resources for investment to improve social and economic services relevant to the national development. This bill, when passed into law, will strengthen institutional governance by improving public sector management skills and accountability in designing, financing, construction, rehabilitation, and provision of infrastructure services. It will also create room for a clear, transparent, and well-delineated legal and institutional framework for encouraging investment and proper allocation of its risks in the provision of infrastructure and related services. One of the major highlights of the bill is that it seeks to provide a robust regulatory framework for the public-private partnership arrangement in Nigeria. Mr. President, my distinguished colleagues, honorable ministers that are represented here, esteemed guests, you will all agree with me that this is the right time for a full-scale implementation of public-private partnership arrangement in the development of our infrastructure. This is the trend all over the world. Ours cannot be an exception. In conclusion, more than ever before, Nigeria needs a robust framework to facilitate and meet the infrastructure deficit of the country. Government alone cannot meet this enormous task in a globally competitive world, which is why the enabling environment is needed to secure the participation of the private sector. I urge you to freely share your views on the bill and contribute robustly during the public hearing, and I assure you that your views will be considered and incorporated in the bill. I thank everyone present and wish all of us happy deliberation. Thank you very much.
The objective of the bill is well spelled out in Section 2(9), Section 2, Paragraph A, B, C, D, E of the bill. The essence of this is that we don't have it in the ICRC Act, but the current bill has this, the objective. Section 4, 5, 6, 7, 8, 9, 10, 11, 13, 14, 15, 16 of Part 2 comprehensively deals with procurement rules for PPPs. This was never in ICRC Act. This has shown the reason why this bill should be passed. Part 4, especially Section 22, is the provision for distinct power for the board, whereas in the ICRC Act, both the powers of the board and the commissions are combined. This is a new dimension. So also the functions and powers of the commission is as contained in section 23 and 24. Without much ado, I want to thank this honorable committee for having the political power to come up with this bill, and I claim the indulgence of all the other stakeholders to support the passage of the bill. Thank you all, and God bless Federal Republic of Nigeria.
Thank you very well. So can I now call on the representative of the Governors Forum?
The Nigeria Governors Forum is largely aligning with the amendments that have been proposed by the RCRC, based on the fact that we have had a long working relationship with the ICRC. And our proposed amendments for this bill is on section 16 and 17. Section 16 is on the right of way, which states as follows: a private sector entity that has been awarded a public-private partnership contract shall have a right of way or easement in respect of the project area, and it shall be the responsibility of the public infrastructure entity to ensure that the private sector entity has unfettered access to the project area. So the position of the Nigeria Governors Forum is that instances where a project will be situated in a state, that approval for right of way shall be sought from the relevant state representative. This is only ideal, being the fact that most projects will be situated in a state, and it is the governor of that state that has authority over the land in that state. So it is only ideal that the project that is going to be situated in that state, approval for the right of way should be sought from the relevant state authority. So we are proposing that this amendment be inserted in section 16. The last point I'm going to make is on section 17, establishment of the governing board. So the governing board for the commission has been established and the members outlined. So the position of the Nigeria Governors Forum is that a representative of the Nigeria Governors Forum, or rather the Nigeria Governors Forum, be made part of the governorship board, or the governing board rather. This is because the Nigeria Governors Forum is the representative of the 36 states of Nigeria, and it is only ideal that they be a member of the governing board, seeing that most of these projects will be executed in their state. You know, apart from just being a member, it's also going to help the governing board where some states are having, or where some companies or private companies are having difficulties executing projects or even getting approvals from states. The Nigeria Governors Forum, or the member representing Nigeria Governors Forum in the board, would serve as a middleman, mediating or negotiating for the board or for the project that is about to be executed. So it is only ideal that the Nigeria Governors Forum be a member of the governing board. That's going to be the end of our presentation. Like I said earlier, we're aligning with the amendments of the ICRC, and we hope that the committee will take our recommendations into consideration. Thank you so much.
Thank you very much.
We have a few comments on the bill. I'll go to the major one. The first is, I would like to take another look at section 3 sub 6, which refers to the composition of a public-private partnership approval committee. And this committee from the bill shall consist of the Secretary to the Government of the Federation, the Minister of Budget and National Planning, the Minister of Finance, the Minister of Justice and Attorney General of the Federation, the Minister of Trade and Investment, the Governor of the Central Bank of Nigeria, and the DG of the Commission, who shall act as the Secretary of the committee. We also note that pursuant to 3.8, the primary role of this committee shall be to, quote, to approve the full business, although it says final, case for projects below a given threshold as stipulated in the regulations to be issued by the Commission, while the Federal Executive Council will continue to give approvals for projects above the threshold as will be stipulated by the Commission. We have 2 comments here. First is that we think there's a need to review the necessity for this committee in view of its high-level composition vis-a-vis for the necessity for improving the ease of doing business in Nigeria. It's our position that given this high-level composition, and as our experience has proven most times, sometimes even calling meetings of such high-level committees could become problematic, especially when they become standing committees, not simply ad hoc committees. And as an alternative, we are recommending that the PPP Regulatory Commission should have the responsibility to grant provisional approvals to these final business cases in respect of projects below the given threshold, and thereafter submit reports to the Federal Executive Council for final approval. We think this will ease and make the process faster. We support this bill, but we hope that the distinguished committee will take another look at this issue of an approvals committee in order to ease the environment in which the private sector operates in the country. Thank you very much, sir. Thank you.
There are existing legislations on Infrastructure Concession Regulatory Commission and the Bureau of Public Enterprises, as well as bills pending. And he wants to also note that contentions set in with particular reference to their mandates. He says that there have been several attempts to address these contentions, and wishes also to point out that there have been efforts by the Office of the Secretary to the Government of the Federation to resolve these contentions, in pursuance of which a circular was issued to address this matter. He has also attached a copy of the circular to the presentation we've submitted, sir. So he says it's against this background that there have been discussions as to whether there is the need to amend these legislations, the bid to strengthen the agencies. Our presence here today is to, he says, to offer assistance to this esteemed Senate committee in view of existing legislations on ICRC and BPE and administrative efforts already undertaken by the Office of the Secretary to the Government. So he says that in view of these, that the Office of the Attorney General of the Federation is most willing and able and would like to provide every necessary support to the National Assembly in their execution of this mandate, legislative function, to arrive at a decision one way or the other. He says that it's in pursuance of this responsibility that he has to protect the national interest and support the National Assembly. And then, sir, wishes to present his assurances of goodwill and best wishes to this Assembly. Thank you very much.
The Federal Airport Authority, we have already presented a memoranda on the proposed act, and we wish to start off by saying that we support the act in its entirety, but we have some minor comments, or should I say a few comments to make. These are issues with the act, the issue of the creation of a special consolidated account and the definition of concession. We seek that the issue of supply and provision of services be expunged from that definition. By our memorandum, which we have already submitted to the House, we have also other minor corrections relating to simple typographical errors, editorial errors, and observations. And in conclusion, I adopt in entirety the memorandum we have submitted to the House. We thank the Senate Committee for its laudable works in this direction, and we say God bless Nigeria and God bless us all. Thank you.
This bill on the change of name, especially the nomenclature of ICRC, we are aligned to the new change because it shows that starting with Public-Private Partnership Regulatory Commission is more broader nomenclature. So in essence, it will have more power on the regulatory aspect. Then we made some observations too. In part 3, subsection 3 of the bill that says the National Public-Private Partnership pipeline of projects shall be submitted to the Federal Executive Council, FEC, for approval. The Ministry is in the opinion that only projects that have reached advanced stages of implementation should be submitted to FEC for consideration. In specific terms, only projects with full business case or in every exceptional cases, both outline business case and full business case should be submitted to FEC. We have in part 5 of the bill under staff of the Commission. We felt in the civil service that there is need for the creation of PPP officer cadre. Because presently, I'm very sure that most of the officers that are manning the units in the MDS doesn't have a particular cadre. They were just deployed from other departments. So that is a submission that should be considered. Then in part 6, under financial provision, the ministry is in support of the grant financial incentives or investment support to an approved project on the approval of the Commission. However, these incentives should be applicable to all MDS and backed by multi-sector holder for the implementation. Our position, the Federal Ministry of Health is in support of the bill to repeal the Infrastructure Concession Regulatory Commission, that is the former one, to the new one. Then finally, we would like to wish and thank the distinguished senators in the Senate Committee on Works for the invitation to present our own position on this issue. Thank you very much.
Thank you very much. I want to assure you that all the comments, the observations, the suggestions you made will seriously be looked into. The idea is we want to come with a very good and robust legislation that will address the infrastructure deficit in this country, as I said earlier. And this committee will do whatever is humanly possible to ensure that this piece of legislation that will come out of this public hearing will stand the test of time. It will not only address the infrastructure deficit of this country, we want to make sure that our country becomes more investor friendly. We want to see a situation where private sector will be responsible for the construction of roads and also be responsible for maintaining them. We even want to see private sector moving into aviation, building airports, and also maintaining them and running them. We want to see private sector to be building ports and harbors, administering them, and also be maintaining them. Equally important, under the health sector, we want to see the best hospitals in this country to be built by private sector, so that our people will stop going to
other countries for medical tourism. Equally important is also the educational sector. Many people take their children abroad to study. I believe we have all it takes to build state-of-the-art universities in this country and train our students, provide necessary and critical manpower for the development of this country. And this is why we come up with this bill. And I thank you very much for your participation, and we look forward to the day when we will call you to come and start commissioning some of the projects that will be undertaken by the private sector. Thank you.
Well, here is where we conclude this edition of Senate 109. Thanks for your time. Join us again next week. Till then, I'm Dennis Adigunloye. Bye for now.